do want to start council in spearheading the working group that produced the report that's the subject of today's technical meeting. I think the depth and breadth of the report speaks for itself, so I'm really looking forward to the presentation this afternoon. I do have a couple of other administrative items to cover with respect to this docket after that. After we receive the presentation from the OCC. So thank everyone in advance for attending. I don't have anything else to set the stage here. We are broadcasting. We do have a court reporter with us. So if there are questions or comments later, please make sure to identify yourself by name and affiliation. And without further ado, I'm going to recognize Consumer Counsel Coleman and her team. Turn the virtual floor over to you and let us know how we want to handle the slides this morning or afternoon. Thank you.
Great, thank you, Chair Gillette, and great to see Commissioner Arconti, the first proceeding I've had the pleasure of seeing you on the virtual bench for. So it's very exciting. Good to see you, Commissioner Karen and Commissioner Bedkowski. While we are pulling up the slides, I'll set the table similarly. As you know, Chair Gillette recognized, I did just want to acknowledge the great work that my team did in compiling this report. We did a lot of field research as well as academic research, and I think the details presented in the report reflect the thoughtfulness of the approach. It also reflects the very helpful engagement we had throughout the process from stakeholders, including many of our low-income advocates as well as the utilities. So we appreciate everyone's questions, comments, presentations, and contributions to the conversation that helped enable us to produce such a robust report. And just before my colleagues will present the details of the process and recommendations that we ultimately made in the report, but I did want to sort of level set at a high level. We approached this issue from a balanced perspective because as the Office of Consumer Counsel, we represent all ratepayers, but we also have been infusing more of an equity lens into our advocacy and have appreciated and supported the authorities' focus as well on equity throughout the framework for an equitable modern grid. When we talk about energy equity, it's been defined as the fair distribution of benefits and burdens of energy production and consumption. So that can kind of appear on many fronts, from establishing a low-income discount rate that will help us move towards a more progressive rather than regressive rate structure, to ensuring low-income customers have access to clean energy programs, and of course the problem of dealing with arrearages, late bills, and how to help customers, enable them to pay their bills as opposed to punitive approaches. We all have recognized throughout the affordability proceedings as well as the discount rate that proceedings that historically low-income customers have been overburdened with energy costs, and those costs do exceed the ability to pay in many cases. So we've all worked sort of proactively on the front end on creating more affordable bill payment structures with a hope that if a customer is able to pay, they'll be more likely to pay rather than avoiding the bill altogether. And that does help all ratepayers, the collective ratepayer, so to speak, when we address that and help prevent arrearages from building up. But we do have a significant arrearage problem in Connecticut, and we're in many respects still coming out of the COVID pandemic. So the issue of what forms of bill collection are both effective and appropriate, and benefits outweigh costs, is a really important one for this commission to be engaging in. And we drew attention over the last few years to the practice of wage garnishment because we were concerned that wage garnishment the harm to individual customers facing wage garnishment, which can have significant social and economic collateral consequences, may actually undermine a customer's ability to pay. So Paola and Alex, my colleagues, will walk through the details, but I think this is the framework from which we approached this, and I ultimately think we landed with a solid recommendation that both protects customers who may be struggling to pay their bills from harmful practices of wage garnishment, but also keeps a process in place to protect all ratepayers as a whole by preventing those who may abuse any protections afforded to hardship customers, whether medical or financial hardship, from avoiding paying bills in perpetuity. So without further ado, I think I will turn it over to my colleagues who will walk you through the process and the findings of our group and the working group. And let's see, do I see Paola? Wonderful.
Yes, I'm here. Thanks so much, Claire. And thank you to the authority for inviting us to present on this report. So I'm Paula Pineda, and I'm a policy analyst and consumer engagement fellow at the OCC. So I'll first talk about if you could go to the next slide, please. For the first background slides outline some of the key details about the underlying investigation and the process that eventually led to the establishment of the working group. So we've summarized here and on the next slide the process that we undertook. We initiated the wage garnishment working group at Puro's request following the wage garnishment investigation that focused on the COVID period. And this working group report and the working group itself are essentially just a broader exploration of wage garnishment practices, extending beyond the context of the original investigation that looked to like pandemic data. If you could go to the next slide, thanks. So I'll also talk a little bit about what the process itself looked like on the next slide, thank you. So primarily OCC hosted 3 virtual working group meetings on September 1st, 2023, October 25th, 2023, and January 10th, 2024. And we also provided the option to have an additional meeting if further discussion were deemed necessary by working group participants. On the following slide, we also outlined some of the other key parts of the process that we undertook, which included engaging with NCLC, which is a National Consumer Law Center, and they were super helpful and provided really valuable resources for our internal research. We also evaluated the appropriateness of performing a DEA, or distributional equity analysis, as a potential way to measure the intangible costs that are associated with garnishment. And my colleague Alex will be discussing this further in a later slide. As part of this process, we also received information and presentations from the utilities that helped the working group better understand wage garnishment practices. OCC also created a survey to collect data on wage garnishment practices from other states, which we were able to share with our counterparts at other states through NASUCA, the National Association of State Utility Consumer Advocates. And another key part of the process was the independent research that we took, the internal research. So we assembled resources and conducted this social science research to identify potential benefits and detriments of the practice. And the next slide is going to give an overview of the legal process for how customers' wages are ultimately garnished. So Tom is going to cover this piece, and I'll be right back for the next one.
Hi, everybody. Tom Wheel, also from the Office of Consumer Counsel. I think it's the next slide. Nope, it's this slide. I'm just going to give an overview of sort of how someone gets to a wage garnishment. So as it lays out here, it starts with a customer who fails to pay their bill on a timely basis. From that point, either UI or Eversource works with the customer to try to bring the account current, offers them, where applicable, payment programs. It's our understanding either a flexible payment program or something like other assistance programs, depending on their eligibility for programs. when the outstanding balance reaches a certain age and threshold, meaning the amount owed has been owed for long enough and has racked up to a high enough level of arrearage, the account is referred to a law firm that kind of continues the collections practices on our, as we understand it, as somewhat what we called, I think, in perhaps the report and in our brief in the underlying proceeding, a pre-litigation stage where the law firm contacts the customer and tries to work out some sort of arrangement to get a payment. If that doesn't work, it moves on to the filing of a lawsuit in small claims court. That lawsuit proceeds. If the company prevails in the lawsuit, the court orders that the customer pay an outstanding balance. That's what's called a civil judgment. And then if the customer from that point fails to pay the amount ordered by the court, fails to pay the civil judgment, the company can file sort of a post-judgment motion for a wage garnishment, which is actually an order not to the customer, but to the customer's employer. It's the court ordering the customer's employer to extract a certain amount of money from the customer's wages and direct that sum to the court, which then passes it through to the law firm and then ultimately to the company. So that's just wanted to give an overview of that's what we're talking about here. That's how we get to a wage garnishment and what a wage garnishment is. And I'll pass it back to Pella.
Thanks so much, Tom. So the following slide highlights just a few key takeaways about wage garnishment that we were able to gather from the available social science research that we studied. So on that first point, we included just a few statistics from the ADP Research Institute about the prevalence of garnishment on a national level. And ADP RI also provides data about the prevalence of particular kinds of garnishment. Importantly, we also wanted to note, and I think as Claire referenced at the intro, that while the current research does offer illuminating findings, various sources agree that wage garnishment and its impacts are understudied, which results in limited data. There's also some overarching protections that are in place at the federal level that we wanted to mention. Particularly, it's Title III of the Consumer Credit Protection Act, or the CCPA. And then under the CCPA, it also allows states to essentially implement their own, to like extend beyond the federal protections. And these approaches vary by state. Even with these protections, the National Consumer Law Center has found that even with certain protections, it might still not be enough to support a living wage. And then I'll hand it over to my colleague, Alex, to talk about the cost effectiveness of garnishment.
Hi, I'm Alex Wong, economist with the OCC. And in 220316, the companies were ordered to provide CBAs, including consideration of social costs. And they demonstrated that their wage garnishment practices were cost effective in that the revenue exceeded attorney costs and court fees. And we can also see on the right, based on Eversource data, that dashed line signifies when wage garnishment begins, and these are all post-judgment payments, and they significantly increase after the wage garnishment. However, a CBA with a societal scope would also include externalities beyond that first level of transferring money between customer groups, but these impacts were not addressed. So we explored the possibility of using a societal cost test and differentiate the costs and benefits between separate customer groups. But many of these impacts are hard to monetize, and we already know that wage garnishment, and it's also clear that there are disproportionate external costs associated with wage garnishment compared to the level of savings that we would see for overall ratepayers, and a benefit cost ratio wouldn't really address the individual protections. Oh, I'm hearing that my audio is breaking up a little. Okay, sounds like you can hear me now. So the a benefit cost ratio would not necessarily address the necessary individual protections that we're concerned with in regards to wage garnishment. So the OCC determined that a CBA wouldn't be feasible or necessary in this case. Next slide. Per RAM filings in 2023, CLMP reported around $88 million in hardship uncollectible expenses to be recovered from residential rate classes, and this was up from $25 million in 2022. And as of April 2024, financial hardship and medical protection arrearages older than 120 days across Eversource and Avangrid companies were nearly 410 million. So these present significant ratepayer costs, which wage garnishment would help with, but the practice is not very common, and it seems to have a pretty negligible impact on bills. For example, based on Eversource's net collections from 2016 to 2020, we would see about 2 cents, I think it was maybe a little less, saved per month, if that amount was credited only towards residential electric customer accounts. Next slide.
So I'll talk a little bit about some of the potential costs that are associated with garnishment that we were able to gather from the social science research that we undertook. So for instance, our research suggested that debt collection suits and the judgment and wage garnishment process can often have procedural justice concerns, and that's primarily due to the fact that there's a high incidence of default judgments in these kind of suits. So in the default judgments, the court will find for the creditor plaintiff without ever hearing from the defendant. So through the lens of procedural justice, this high incidence of default judgments can suggest that consumers facing these debt collection lawsuits are often just not involved in a key part of the process that can result in the garnishment of their wages. Another key potential cost of garnishment is the impact that it can have on consumers' financial stability, access to credit, and job stability. So garnishment significantly, it can limit consumers' budgets, and that in turn can result in consumers not being able to afford other bills, and it just perpetuates this cycle of debt. It can also impact job stability. In the months after garnishment, affected workers tend to separate from their jobs at higher rates than non-garnished workers, and these high turnover rates could essentially be due to the fact that workers will often leave their current job in order to avoid garnishment, because even taking a lower paying job could be a better alternative financially relative to staying in their current position and their current wages being reduced by garnishment. Garnishment can also have detrimental impacts on the mental health of garnished employees. Even prior to garnishment, consumers that are dealing with debt may already be struggling with the negative mental health impacts that are associated with indebtedness. So in addition to these possible impacts that we outline in the report, garnishment can therefore just worsen the situation, adding another factor, adding the increased stress of an even more limited budget. Garnishment doesn't just affect the garnished employees, it can also have external costs to their employers. So for example, there are administrative costs that are associated with the compliance with wage garnishment orders. So the ADP Research Institute finds that employers are also exposed to financial risk when their employees' wages are garnished, since they could be liable for the judgment amount if found non-compliant. And worker productivity can also be negatively impacted by garnishment. And extending beyond these impacts that we look at, like on an individual and household level, there's also studies of broader garnishment trends that can point to like more broad disparate impacts among garnished workers. So as we can see on the slide, there's particular demographics, including like middle-aged workers, employees earning between 20K and 60K, and employees working within particular sectors like the transportation and utility sector. They tend to be overrepresented among garnished workers. And there's also zip code level research that has found disproportionate representation across both race and education. So even after controlling for income, workers that live in neighborhoods with a high share of Black residents and in neighborhoods with a high share of residents without a college degree tend to have higher garnishment rates. And on the next slide, we'll talk about options for future use of garnishment by, oh, sorry, no. Yeah, this is Alex's part.
Yep, I'll take this. This is just touching a little bit on the benchmarking we did. So the OCC looked mainly at wage garnishment in 11 other jurisdictions through researching online, the NCLC, and we had a survey with other consumer advocates. And of the states, Massachusetts was the only other jurisdiction that we could see that used wage garnishment to collect utility debt. And we also found that Michigan and Rhode Island had forms of absolute protection for customers in potentially life-threatening situations that were similar to Connecticut's protections. But Michigan and Rhode Island did not use wage garnishment for collecting utility debt. And we found that other jurisdictions showed other ways that payment incentives for medically protected customers could be addressed through the processes required for termination of service, and also through efforts to put customers on payment plans. And there are two of the examples from the report below, which you could read on your own there from New York and Michigan. This will, Paula will take over on potential.
Yeah, happy to jump in now. So the next slides will talk about the options for future use of wage garnishment by Connecticut utilities. So based on OCC's review of the data, the input that we received from stakeholders and experts, as well as our independent research, we evaluated different options for limiting or prohibiting wage garnishment as a means of collecting utility debt. And in the report, we provide our recommendations. So from a high level, OCC's recommendation is to end the practice of unrestricted wage garnishment. OCC found that the potential financial benefits of garnishment revenues are trivial compared to the significant potential social costs upon those who are directly affected by the practice. And if utilities are permitted to continue to garnish customers' wages, OCC sincerely recommends that PURA first develop and impose limitations upon the practice. So as you can see on the slide, we outlined some of the recommendations that we considered and ultimately decided against. So the first being the prohibition of wage garnishment for hardship customers, both financial and medical. With this particular option, the companies wouldn't be opposed to this option, and it does appear to be technically feasible since utilities already track hardship status of their customers. This option would also protect particularly vulnerable customers from the negative consequences associated with garnishments that we discussed earlier. And because the companies could opt to pursue garnishment for non-hardship customers, the potential financial benefits of garnishments wouldn't be entirely eliminated. However, this partial limitation would prevent utilities from garnishing the wages of medically protected customers, which is the group that, according to the utilities, necessitates wage garnishment, while at the same time still sanctioning the practice for non-hardship customers, including any and all non-hardship customers that are making more than 60% of the SMI, the state median income, even if they're only making marginally more. And this is a group that has not been identified as problematic in a way that would justify garnishment. So with this option, it seems like it would just produce an unfair result to the working, low and moderate income customers that would neither resolve the imbalance between the potential benefits and costs of the practice, while also not really addressing the utility-specific concerns. With the second option that we considered, the full prohibition of garnishment, this is an option that Operation Fuel would support. And while this option obviously eliminates the potential to recover any money through garnishment, it would protect low to moderate income customers who are making only marginally more than the 60% SMI from the potentially dire consequences of garnishment. Because this group of customers wouldn't qualify for hardship designation, they would not be protected by anything less than a full ban on the practice, since the utilities do not track income data and there is no practicable way to design a more limited wage garnishment prohibition that would automatically capture these moderate income customers. While from the utilities perspective, this limitation would remove the ability to address outstanding debt of medical customers protected from disconnection, OCC believes that there are other means of dealing with this issue that could be more targeted to the customers that are allegedly accruing significant arrearages. So on the next slide, we will discuss what our ultimate recommendations are, which is essentially a modified model of this total prohibition, in which wage garnishment is prohibited as a general practice, but the utilities could proactively seek authorization to request a wage execution in scenarios where they're able to determine that wage garnishment would not impose undue burden upon the customer due to sufficient income or assets. So this model, we think, would protect all customers from the social cost of garnishment, but would provide the utilities an avenue to use the tool just in particular cases. For example, if they have reason to believe through the assistance of their legal collections firm that a customer has ample financial means to pay their utility bills. In our report, we also noted for our proposed wage garnishment model that OCC suggested a threshold of 75% SMI and welcomes the authorities' input and judgment regarding the appropriate income threshold warranting a wage garnishment action. So we also just wanted to take this opportunity to further clarify our recommendation. So that suggestion that we made in footnote 133 to use the 75% SMI as a floor for eligible wage garnishments, it does not mean to suggest that anyone who makes more than that should be eligible for wage garnishment. We think just that it should just be like a starting point for fact-finding from a more holistic lens that would consider income, assets, medical considerations, and family obligations. So for the company to demonstrate that the wage garnishment would be fair. And if wage garnishments are to continue to be used by the companies as a collections tool, we believe that additional notification requirements should be instituted in order to promote greater fairness. So for instance, the working group didn't receive requested transcripts, recordings, or scripts that were used in communications by the legal collections firms. So OCC believes that more information about this aspect of the collections process on the part of both the companies and of the legal collections firms would be helpful in devising just a more helpful communication strategy for customers that are subjected to this practice. Thank you.
Thank you. Just want to make sure I'm not cutting anyone off. That's okay.
We're all set. Thanks very much.
Thank you. Maybe I can open with a couple of questions and then we can open it up more broadly if there are stakeholders who participated in the working group on the line who want to add anything additionally. But just a quick question on the 75% SMI that we were just touching on. I think my first question is, does that correspond to a specific program or some other data point that DSS data sharing would facilitate? I'm just not as familiar with like we always hear 60% and 160%. So the 75% isn't as familiar to me. And I'm just wondering if that's a data point that could be easily matched through the DSS process.
I'll jump in and others may add. That's a great question, Chair Gillette. And in fact, these recommendations we issued earlier this summer before we really got into the tiering process with DSS to see if we could target income levels at a more granular basis. So the recommendation was not specifically tied to any particular program eligibility for DSS customers. It was really a consideration that those 60% SMI below are likely not to have the assets or income that would justify a wage garnishment, and kind of wanting to create a bit of a buffer for those who are on the margins. But I do think that's a great suggestion. As we develop the low income discount rate tiering, it might make sense to use a same level threshold as we establish a more granular tier on the LIDR. It could be applied here as well.
Awesome. Thank you, Consumer Counsel. I think you anticipated my follow-up question, which is going to be, so, and I know I'm crossing dockets here, even if it is similar stakeholders. But if we assume the hypothetical for a moment that PURA does move forward with restructuring the LIDAR tiers such that there's, more than the 2 that we have today, and thinking through this recommendation in front of us, would it be an acceptable outcome in your mind if we matched that 75% recommendation to a comparable income level that matches a tier in LIDAR? Like, is that a reasonable way to interpret this recommendation?
Yeah, absolutely. This, I would call this a soft, flexible recommendation, really to be used as a starting point to assess what the customer's ability to pay is, and certainly allow for further vetting of the particular circumstances of each individual customer. The goal in our mind was to create a process of review that would allow for all of these considerations to be looked at collectively. So I think your suggestion, we would have no concerns with that. Any further thoughts from the team?
I would just add, Tom Wheel again. I think the 75% level was sort of just a conceptual placeholder as a way to kind of try to get at the difficult thing about addressing wage garnishment, which is that anecdotally, and as far as we can tell from the limited available data, the demographics that it most affects are those marginal demographics for whom there aren't very many state protections, either through PURA or perhaps through DSS programs now. Because what we're talking about here most practically are people who do have jobs, who have levels of income that are frankly attractive enough or certain enough to inspire the legal collections firms to pursue a wage garnishment against these customers. Because part of the process, I didn't maybe go into too much detail in on my little part of the presentation here today, is that there is discretion in the way the system has worked historically, that the part of the process is that the legal collections firm kind of looks into what data they can determine about a particular customer to sort of see, does this person have assets, or in this case income, that are kind of worth, that there's a good chance that we could get at through wage garnishment. So that kind of tends to be to affect those marginal customers who maybe are just outside the lens of state level protections generally. But I think it is, it makes sense to consider that, and because it is just ultimately the idea of kind of implementing some threshold that accounts for that does a better job of accounting for that than sort of just the hardship protections that exist in our current system makes a lot of sense.
Thank you. And I should have started, I have a way less in the weeds question that I should have started with. In 220316, if I'm remembering correctly, it spanned multiple sectors, not just the electric and gas companies that are subject to the 240501 docket. Is it appropriate to consider the recommendations from this working group report as more applicable to gas and electric, I know there's some nuances with the types of collections that water companies are generally able to do anyway. So I just wanted to clarify that question.
I can jump in on this one, Chairman, because I spent a lot of time on that docket, and I'm pretty familiar at least with the data in that docket. So that, just as a caveat, we looked really closely at sort of what was going on the ground level with Connecticut utilities and wage garnishments in that docket, but only specific to the kind of window in time that was being examined there, which was the gap between when the moratorium order started and essentially when the investigation started. But looking at that slice of data, it's my recollection that I think the majority of garnishments were actually gas customers in that docket. So that being said, that would make a lot of sense to me. It's my understanding that there isn't much distinction, and I invite any utility folks who are on the call to correct me on this. But it's my understanding there isn't much distinction in the practice historically as between the electric and gas companies for how garnishments are pursued. But and as you mentioned, Chairman, there does appear to be a distinction for water companies. That's water companies don't engage in wage garnishment, but they do engage in other collections practices.
Thank you. And I can repeat this question when we're to the portion for general stakeholder comment, but I think what I'm in the near term trying to get at is if the authority took action on the working group's recommendations in the context of this docket, obviously we don't have the water companies at the moment. So trying to ascertain whether that means there's more work to be done, like we have to, it's kind of a process question. Like, do I need to return to, the other docket and investigate the application of these recommendations to the water companies? Do we feel like we've tackled the majority of the program if this is taken up in this decision? Any thoughts on that question?
Yeah, I'm fairly certain this is working off full recollection from the wage garnishment investigation 2 summers ago now. But I'm fairly certain that as Attorney Wheel said, that the water companies both said they did not engage in wage garnishment. So in that respect, there's not a necessity or an urgency to address the water context. That being said, I do think any process the authority might consider putting in place with having a PURA or EOE level engagement or of review, so it's not, an unrestricted wage garnishment process at the discretion of third-party legal collections firm, but there's some PURA-led review process that could easily be applied to the water companies as well.
Thank you. So speaking of process, and just going off the slide that we still have up, did the working group kind of get into the next level of detail here and weigh in at all on what that process might look like? Like, are we talking about a motion to the authority? Are we talking something less formal where it's like communication to EOE? Just wondering if there had been any kind of discussion of that next step.
There hadn't, as I recall. I don't believe we got into that level of detail. I think there was some discussion. I think we first kind of broached this idea either in the last working group meeting or for the first time in our draft report. I do remember there was some feedback from the utilities with some concerns about the kind of the feasibility of this, but I don't think we didn't get into discussions of how exactly it would work. We did note in our report that there are no other states that have this particular process because we were only able to find one other state that does wage garnishment for utility debt, but there are other states that have similar conceptual processes. I think New Hampshire, off the top of my head, is a state that has sort of a subjective application process for shutoffs, where utility companies have to approach their regulator to request shutoffs for certain levels of protection. I think there are other states I think that have other kind of similar check-in processes with their regulator for before they're allowed to pursue other kinds of collections. So just adding to say that maybe we could look more closely into the mechanics of how those other states do it, but we haven't yet.
And I will add, in the report, there are references to the New Hampshire administrative rules for disconnections of service to medical emergency customers, which, as Attorney Will referenced, was a point of reference for us in looking at how a utility would seek permission from the authority. And there is a criteria outlined within that that could be useful to the authority. I believe we also referenced a settlement in Rhode Island. It was a litigation settlement, but that did outline a process which involved a review by the Division of Consumer, forgetting the name of the division, but it's the Consumer Education Division, which would conduct a review of terminations for medical hardship customers, which could also apply. I think we've found in looking at all these policies that there's a significant amount of overlap, or there's an important intersection in terms of medical protections and wage garnishment. So I think while these aren't examples that specifically address wage garnishment because it's just not happening in other states, they are appropriate to consider in terms of the process we could apply here.
Understood. So that you may have just addressed my follow-up question about, I was going to ask if there was any discussion about how to interpret or how to demonstrate that it would not impose undue burden. Is the best place to look that Rhode Island settlement or the New Hampshire processes? Is that standard borrowed from there, or is this a standard that was first discussed by the working group?
Yeah, I actually have the New Hampshire code up, so I'll just reference what they do. And it states, in deciding upon the reasonableness of a payment arrangement, or in our case, it would be, the ability, the reasonableness of a wage garnishment. They consider the size of arrearages, the estimated size of the customer's future monthly bills, customer's payment history, amount of time the arrearages have been outstanding, the reasons why the arrearage is outstanding, and whether or not that will continue, and the customer's ability to pay, which is not defined, but in our view, isn't just about an asset level or an income level, but takes into consideration, what other challenges the customer might be facing, particularly if there's a medical protection. Are there big hospital bills that have racked up? Are they in a treatment at the moment that's costing a lot of money that's preventing them from paying? Those types of substantive ability to pay analysis.
I'll also add, Oregon is another state that has that they have a somewhat similar process where a disconnection in Oregon, I think for certain classes of customers, requires notice, like public notice. The utility has to give notice to the authority, and they're the equivalent of their authority. And I think that the customer has an opportunity to request a hearing. So it's sort of a borderline version where there's notice and process can be elected, but isn't necessary if it's not requested. The only other thing I'd add, sort of echoing Consumer Counsel Coleman's point, is well, directly echoing it, part of the consideration here is the potential lag between the information that even a court or DSS might have about someone's circumstances versus their actual circumstances, meaning like their listed income, even based on tax returns or something, might not reflect the actual condition that they're in at the time. And I echo that to say the other reference that we have in our report is there's somewhat of an analog in our court system, actually in the context of wage garnishment. If a plaintiff, a defendant in that circumstance can file with the court for an exemption of a wage execution order, which is there's a lot of discretion, it being a court process there. My understanding of that process is essentially like a customer can sort of write a letter to the court explaining why they need a reduction to their order, and the court can grant that. But just raising it as it's another process where there's a way for a customer to kind of put evidence on the record, if you will, demonstrating or attempting to demonstrate why the particular outcome doesn't make sense for them individually.
All right, thank you. I guess last question from me is there is there any difference in the applicability of the recommendation here to the medical protection customers? Sorry, I'm struggling to ask this question. So hypothetically, if the medical protection customers became a question that the legislature was going to take up, similar to last session, is there a difference between the recommendation that OCC's developed here for wage garnishment practices for financial hardship customers versus how that might apply to medical protection customers if legislation allowed us to apply it? And I can try again to phrase that if it's not entirely clear.
Thanks, Chair. I think I understand. You're seeking to kind of play out the interaction between the medical protections and wage garnishment, and we absolutely considered and evaluated that, and that's one of the reasons, given the permanence of the medical protections currently, that is one of the reasons we decided to recommend to leave open the option of using wage garnishment in limited cases where we are seeing, an abuse of the protection in terms of a medical customer who does have the ability to pay, but because of the medical protections are, at this point ongoing, that would be a way to address in a targeted way those customers that do have an ability to pay but are protected under a medical protection and aren't paying their bills nonetheless. So if the legislature or the authority is to consider reevaluate the medical protections, and I would say we think medical protections are important, but we are very supportive of a deeper review of medical protections. And we tried to do a little benchmarking incorporating into this report, but wouldn't say it's fully complete. We do understand some other states are currently evaluating their medical protections as well. Colorado is going through a critical care symposium, I think they called it, or critical care evaluation that we've been recently listening into. I think there's a lot we could learn from other states to evaluate what the right balance is to protect medical customers, but with reducing the arrearages that accrue, and the targeted wage garnishments under sort of PURA supervision is one way to get at that.
Yeah,
Oh, go ahead, Attorney Will.
I just add that it's a great question because I think we've spent a lot of time internally thinking about these two subjects really similarly. At least conceptually, it's a similar kind of problem, meaning a similar kind of issue on both sides, where we recognize that there is a potential for gaming the system that in the kind of frameworks that exist on both sides here. Whether or not that the system is being gamed, and certainly to what extent it is, we can't know, and when we're not sure, we're totally in alignment with some other working group members on the numbers. But we acknowledge that like there's potential for people to abuse the protections that are in place now in order to either avoid shutoffs or just generally avoid paying their bill. But I think our collective perspective as to both scenarios right now is that we just have to be careful not to use too blunt of an instrument to close those gaps, to close those loopholes at the risk of hurting people who shouldn't be closed out. So I think there's definitely a corollary there that is particularly for hardship or for life-threatening hardship medical protection. I think probably everyone agrees we can't have a system that risks one person dying as a result of the the restrictions we put in place to prevent gaming the system. And I think similarly for wage garnishment, we don't want a system where it's possible to send one person into an inescapable kind of spiral of debt and poverty to make them make it even more impossible for that person to pay their bills. So it's a really tough question, but I absolutely appreciate and acknowledge your point that there are definitely similar concepts.
Thank you. I did have a question about the 2 cents issue that was covered earlier in the slides, but I might hold that. I've been monopolizing the question time. So I'll see if there are questions on your presentation, and then just to give stakeholders and participants the heads up, particularly if they participated in the working group, I will open the floor to others for comments or after we take any questions on the presentation. Commissioner Karen.
Thank you, Madam Chair. Thank you very much. So this was a very insightful and enlightening presentation, so I really appreciate that. Let me start with just a few questions, nothing crazy, but I'm starting with what I have is slide 6 concerning the ADP research from 2017. Obviously 12 million employees is a really good sample size, so appreciate that. But is 2017 the latest amount of, or the latest data that we have for this? And secondly, were there any other state breakdowns, i.e. New England regionally by New England or Connecticut particularly?
I can touch on that a little bit. So to our knowledge, that is the most recent data on a national scale. As we mentioned, like the data on wage garnishment is very limited. And that's like broadly on wage garnishment, because on like utility specific garnishment, it essentially doesn't exist. But yeah, so there is the ADP study. There's a 2017 one and I believe a 2013 one. So that is the most recent. And in terms of data on like different regions, I think
I can jump in here, Paula. We did it, as she referenced, we did survey all states that have that are part of the National Association for State Utility Consumer Advocates. We received disappointing results, which are on, I think, page 40 of our report. We got 4 or 5 states to reply to that, all of whom confirmed no, they didn't do this. I'll say anecdotally, when I asked at our recent meeting in Wisconsin last month, if there are jurisdictions that are familiar with this, I got blank stares and a lot of comments like, you guys do that? I mean, that's sort of the raw answer I've gotten as we've tried to seek more information, that this is not a common practice across the country. We referenced Massachusetts as the only other one that we could confirm that yes, it is allowed, but we also have received feedback that it actually doesn't happen very often. It's a sort of an exception and rare case. And I believe in the working group, the Eversource team confirmed it was rarely exercised, and may be able to confirm that. So we acknowledge that this is older data than we'd like, but any of the newer anecdotal data we were able to collect confirms that this is not a common practice at all.
Thanks. Yeah, frankly, I found it a little surprising that we're like one of the states, or less than a handful of states. So that was enlightening. For some of the other states' programs in lieu of using wage garnishment, they must encourage payment plans with the utilities, much as we do. Although obviously our LiDAR dockets and some of the other things we're trying to do may be expanding. Are you seeing similar things in other states, either that we're approaching or that they're already doing?
I can try to address that, Commissioner Karen. We tried really hard to get a sense of that. And it is a situation where the closer, as I'm sure you've observed probably like in your interactions maybe at NARUC, that the closer you kind of try to compare any two jurisdictions in this world, the more you realize that any single factor that's different kind of creates a strange spiraling effect of affecting hundreds of other factors. So we did try to isolate that. That's actually how we kind of narrowed down which states to look at, was to try to find the states that are the most analogous to ours in terms of the protections we already have in place and the overall programs that we use for affordability. For us, we tried to focus on specifically medical protection particularly because we're hearing from the utilities that wage garnishment is essentially sort of like the last gasp option for customers who have full protection against shutoff, where there's no other option to ultimately encourage them to pay. So among the states that were most similar to ours, it was really difficult for us to compare when you start looking at the details of, like, do they have a matching payment program? What are the eligibility criteria for that? What kind of discounts do they have? Ultimately, we tried, but we just couldn't come to any conclusion that was sort of publishable at any means of a way to kind of compare this stuff in a helpful way. So that's probably a frustrating answer, but that's...
No, I appreciate that. And I can imagine among jurisdictions, you have different demographics in different states and even within certain regions. So it would be hard to compare the apples and oranges, I guess. And I'm noticing from the graph that it seems that the higher the payment is, or the garnishment is, the sooner they seem to pay it off. But obviously, the lower it is, the ability to pay seems to have fallen off. And consequently, it'll take over 10 years to pay that off. I don't think anybody wants to see someone's wages garnished that long. Anyway, thank you very much for the working group. This, like I said, is pretty enlightening, and I appreciate all the effort. And thank you very much, Madam Chair.
Thank you. Other questions or questions for the Consumer Council?
Madam Chairman, if I may just jump in here for a second.
Of course.
Thank you very much. First, to echo Commissioner Karen's comments, I'd like to thank the group for really an excellent report. Interesting timing of this. This is a delicate balance. As you know, we've been under a great deal of criticism, if you will, lately about some of our decisions, because part of those decisions were taking care of bad debt at companies. But it's a great vehicle moving forward. Nobody wants to see anybody live without utilities, without electricity. But I do have a question. When wage garnishments, and this might, I don't know if anybody's, I know Sobolewski's might be around. In the past, when wage garnishments were in play, did OCC receive complaints?
I can try to address that also, Vice Chairman Petkoski. I think we would need Rich Sobolewski's look back historical understanding.
I'm just very curious that once, I mean, at one point, it was very aggressive wage garnishment, or I shouldn't say wage garnishment, negotiations with legal firms with people that were behind on their payments was very aggressive. But I was just wondering what the Consumer Council contacted about this aggressive payment.
I know what precipitated this initial investigation was actually based on a customer complaint that actually had to do with collections practices and a concern about credit reporting. That's actually sort of what ultimately brought to our attention that wage garnishments were happening, particularly during the pandemic, because again, that's sort of how all this, we're sort of outside of that context now. So the reason I jokingly, but not so much, said we might need Rich Sobolewski for that is that, at least in my very comparatively short experience at OCC, it hasn't been something that we've heard about it. And I know that our experience in the underlying docket, it was surprising to us to learn about the number of open wage garnishment dockets in small claims court. So we weren't aware, at least those of us who haven't been around very long, weren't aware of the scope of what was going on.
Okay, thank you.
And just to add to that, Commissioner Bykowski, I think one of our concerns with the process has been that because it's sort of handed over to a third-party legal collections firm and run from there, without any interaction with the authority and very limited interaction with the utility from the review we did during the COVID pandemic, at least. It feels to us like a process that has been very disconnected from the authority, from our office, and that a person receiving a wage garnishment, first a judgment and then a wage garnishment, may not even know how to get in touch with us or know that there is a regulatory process that dictates sort of the terms of this. And that's why our recommendation to bring in a level of review at PURA, potentially through EOE, is really important.
Thank you very much. Appreciate it.
Thank you.
Thank you. Are there any other questions for OCC? All right, seeing none, Consumer Counsel Coleman and your team, thank you very much for the presentation, for addressing your questions.
Thank you. I really appreciate the opportunity to share. And again, thanks to my awesome team for their great work on this.
Thank you. Are there members of the working group that would like to be heard on their perspective or anything further? I know that was captured to some degree in the report, but if anyone wanted to elaborate on their position, we want to provide the space for you to do that. I did see Mr. Trainer come online, so I'll give it to him first, and then I see Attorney Roswig second. So Mr. Trainer, please.
Yes, yes, thank you, Chair, and thank you to Consumer Counsel Coleman and your team for the working group. I just want to add a couple points and try to make some clarifications. Here, there was some discussion around limiting the wage garnishments to a population potentially over 75% of state median income. And there was a discussion how that relates to the LIDR and the data that we're receiving from the Department of Social Services. Currently, the way the scope of the Department of Social Services data sharing is that we are only receiving information on customers that are less than 60% of the state median income, and 75% is greater than the 60% SMI. So those customers are not currently in scope for one, the LIDR, and two, the data sharing. If the determination was made to align the wage garnishment kind of threshold with the 60% SMI, like all the other programs that we offer, like SEEP, Connecticut Energy Assistance Program, and kind of the LIDR as it sits today, that we would be able to kind of figure out and determine which customers kind of would qualify or wouldn't qualify for a potential wage garnishment. So I just wanted to put that point out there, that we currently don't know or track or receive information on moderate income customers above the 60% SMI. And to, I think, Ms. Anita's point, there are customers even today that make $100 or less above that 60% SMI that don't qualify for the programs or protections that we offer, or the SEEP. So regardless of where that threshold is, you're always going to have customers that are right on the border of that threshold. In addition, there was some information on medical customers and how that kind of relates here, and to put them on payment plans. The last thing the company wants to do is shut anybody off, or go down this legal path. So we really work with customers beforehand to try to get them on the programs and protections that they qualify for. About a half a dozen times since the pandemic started, we've auto-enrolled customers, including medical customers, on our New Start program and yearly on the matching payment program, if they qualify. So customers have had ample opportunity throughout the last 4 years or so to kind of resolve their balances, and what we're seeing is that medical balances are increasing. It's not something that we haven't tried to get them on a payment arrangement. We try very hard to get customers to pay their bills, to limit the amount of dollars that are passed on to the rest of customers. And Attorney Wheel had mentioned another point about a process that's in New Hampshire. for the medical emergency process. So I just wanted to point that out and talk a little bit more about that. In New Hampshire, if the commission approves a disconnect of a medical customer, we can go out and actually perform the disconnect. There's a lot of communication that happens beforehand. There's a lot of back and forth between the utility and the PUC in New Hampshire. We provide a multitude of different documents and information relating to payment histories, customer contact, bills, basically a whole account history of what's happened there. And oftentimes the PUC or somebody on their staff reaches out to the customer to try to get them onto a payment plan before we shut them off. Because again, that's the last thing we want to do. But we do have a fiduciary responsibility to collect any of the balances that are owed, and wage garnishments are just one of the tools. Although a small tool, we do prior to COVID about 100 a year. So it's not like a disconnect or disconnect notices where the volumes are higher than that. But it is one of the tools that we do have in our toolbox. And then in New Hampshire we have that, but it only happens a few times a year up in New Hampshire for medical emergencies. And there was also a comment related to wage garnishments in Massachusetts. And as I think it was Attorney Wheel commented, it is a very minimal. I can't even think of any that we've done, the last 10 years or so, outside of COVID. So it's very few and far between for our company. I don't know about any of the other Massachusetts utilities, if that's something that they do, but I'd be surprised if there was more than 50 in the past 10 years. And that's all I had. But thank you to everybody.
Thank you. Attorney Roswick.
Thank you. So I wanted to, can you see me all right? It's not coming up. Okay, great. Thank you so much to the Consumer Council for the presentation. Excuse me. So I think a really important point that you raised was this impose no undue burden. I think that's, Commissioner Gillette, you raised that as well. I think it's a really important issue to talk about. It is, and not always necessarily related to what someone sees on paper in terms of the value of someone's home or even salary, but rather what is the current financial situation of this particular customer. People who are in medical crisis or financial crisis, it might look one way, but it would be an incredible burden. There has to be a process to really understand where this particular customer is at. What is their what income do they have? What additional income do they have to make payments? And that can be done in a number of ways, and there are a number of state programs that sort of go through this process when they are asking residents to repay certain benefits. The other thing that continues to concern me is that the relationship of this discussion to cutting back on medical protection. I sort of continue to be confused, and perhaps that collections doors will reopen, but we hear a lot about customers who have the resources to pay utility arrearage, but we will continue to say there is an entire collection scheme in the state of Connecticut for doing that. There is garnishment, there is bank execution, there are liens on property. So, and obviously there are judgments to be entered. The companies will have the authority to continue to do that regardless of, what the determination is made, in this particular proceeding. By all means do that rather than literally put someone's life at risk. The commentary that people are abusing the process, well, if they are above the threshold to be garnished, to have, banks accounts executed on, then that is a collection option that is open to the companies and certainly always was prior to the pandemic. Finally, Mr. Trainer talked about, the numbers of customers who were put into plans. Again, our ongoing concern is the communication to these customers, that they didn't understand what auto enrollment was. And we're finding that now because, whereas we appreciate that the company is articulated that they don't like to terminate service, we're currently, in an atmosphere where thousands of customers have actually had their service terminated. So, as we look at the garnishment issue, as we look at all the collections issues, I think this is part of the larger framework. Thank you.
Thank you, Attorney Roswick. I appreciate that comment. I'm not seeing other hands. Are there, here we go, Mr. Taraj, and if other folks who want to offer comments on the working group report could please get into the queue by using the raise hand function under the reactions tab at the bottom of the screen, that will help me. So let's go to Mr. Taraj, please.
Thank you, Chair Gillette. Operation Fuel first just wants to say thank you to OCC for convening the working group, their dedication, their time to the agendas and the presentations and the report at the end. Operation Fuel appreciated the opportunity to participate in it. I just have a general question and a request. I'm not sure if it applies to OCC or to the companies, but in one of the attachments, we did see a heat map related to the number of wage garnishments around different towns. If we can see if we can get that for the medically protected customers as well, just to see where more or less where the need is great. I think that would drive a lot of the conversation too, as Operation Fuel and other stakeholders prepare for our comments that are due next week, and as we look to it in the future too. So just a request, not sure how viable that is in the future, but just something to throw out there. But again, appreciate OCC and other stakeholders in this working group. Thank you.
Very good. Last call for comments on the report. Okay. All right. Thank you very much. So as promised, I have a administrative matter related to this docket, not specific to the report. I see members from the companies, OCC, Operation Fuel, and we are broadcasting this and have a transcript. So make sure that anyone not present today has a chance to review this. I just wanted to take the opportunity to cover the next steps on some of the process items that are before us. We will issue a follow-up correspondence, a follow-up in writing what I'm about to say, but I want to make sure if there's any questions that we are fully understanding each other. So we heard at the last technical meeting that the utilities require some guidance. I think the date that they asked for actually was August 15th, which is today. I'm not sure that we're going to get it today, but imminently, I think within a reasonable time period. So understood from the last technical meeting that there were some items that they needed guidance on today or around today in order to execute for some of the fall. As many people may have seen, we also issued some additional discovery and interrogatories trying to understand the differences between some of the finer points in the new MPP implementation, where there are differences between Eversource and UI. We have since gotten some follow-up discovery as recently as this Monday that deal with costs and implementation if we were going to pick between one or the other. And I also understand or recall that we all had a group conversation at the first technical meeting about the desire to standardize. I think what's clear to me from the discovery is that that there's at least 4 items where even if we had a desire to standardize, we couldn't possibly standardize in time for November 1st, if I understand the timelines from Monday correctly. So what the request is to the group is when you see the motion ruling, which we are going to issue a motion ruling again, maybe not today, but imminently, it is going to contain and address, you know, some initial guidance. The 4 items, I'm saying 4, let me just scroll through, it could be 5, and I'll read them out just to make sure we're all on the same page. Those 4 or 5 items where we could not standardize by November 1st, we are going to ask people to focus on in their briefs, especially. So everyone's had the opportunity to weigh in on those so far, but we're really going to ask people to drill down in their briefs into what the path forward should be on those items. So let me say this slightly differently to see it, make sure that everyone's understanding me. We have 4 or 5 items that it feels like we have no choice but to allow the utilities to do their respective preferences if we're going to launch by November 1st. So I need feedback. The authority needs feedback and briefs on what to do. Do we pick a decision and ask or do we pick a lane and ask the utilities to adopt the preferred proposal in time for November 1st of 2025? Do we let them operate in perpetuity at their preferred path forward, recognizing that there will be differences? Hopefully you're getting the flavor of my question. So as I see it, and I do appreciate Consumer Counsel Coleman and Mr. Trainer, you giving me some context clues here that I'm not totally off the rails here. But if I could just highlight what I think are the areas that fall into this bucket, and happy then to see if there's any questions. So the first bucket, the new MPP monthly payment calculation with SEEP. I understand there to be different ideas and then an associated timeline to bring us into compliance with standardization. Second bucket, the new MPP monthly payment calculation. Third bucket, new MPP re-enrollment if there's a fail out. Fourth, new MPP auto enrollment November 2024. I think that might be it. So that's kind of where we think we are, like that those 4 buckets couldn't possibly be standardized in time for November 1st. Happy to be corrected if we're misinterpreting the discovery. But I don't think we are. So let me stop talking. Is that clear? That the too long didn't read it version of what I just said is, number 1, we're working towards a motion ruling. It's going to give as much guidance as you can so you can start your November 1st preparations. Number 2, you're going to have the opportunity for briefs. Would really appreciate folks focusing on those 4 buckets for briefs. Number 3, we're still issuing a draft decision, in which point you can comment to your heart's content. Questions on what I just covered?
Nope, I think from my side, it's clear.
Okay.
Thank you.
Thank you. Okay. Very good. Anything else for the good of the group before we adjourn? Okay. and we're a couple minutes ahead of schedule. So again, let me thank everyone for their participation today, especially since this was not originally on the docket. So I appreciate everyone's flexibility and participation. And we will look forward to your continued discovery responses for the remainder of this docket.